Welcome. Today we have Jason Arbuck and Frank Robinson from the Cassels law firm in Canada. Jason is partner and co-chair of the Hospitality Group. His practice is devoted to hotel financing and acquisition transactions, hotel management arrangements, and hotel ownership issues. He's focused on cross-border transactions, and he has significant experience in drafting and negotiating hotel purchase agreements, hotel management agreements, loan and credit agreements. We also have Frank Robinson, who is partner and co-chair of the Hospitality Group as well. He advises Canadian and international companies on all matters relating to franchising, licensing, and distribution, including structuring and expansion strategies, legal and regulatory issues, contract drafting and negotiation, compliance with the Canadian franchise disclosure legislation, and he provides counsel on mergers and acquisitions, along with general corporate, commercial, and contractual matters to companies in the hospitality industry. Let's welcome Frank and Jason, as today they're going to be talking about legal issues you may not know about in Canada.
Thanks so much for that introduction, Taylor. Let's start off with some franchise law in the form of a short backgrounder and some recent developments. Similarly to the United States, Canada has pre-sale franchise disclosure laws in 6 of the 10 provinces, each of which require a franchise disclosure document, or what we call an FDD, to be provided to a prospective franchisee at least 14 days before signing a franchise agreement or paying any money in respect of the franchise. Take note that there's no federal law and no provincial laws in the other 4 of the 10 provinces in Canada, where franchising is essentially unregulated in any specific sense. Many of the major hotel chains have significant franchise networks in Canada, so that's why we're going to explain some of this to you today. Due to the broad application of these franchise laws, certain relationships, including licensed or managed hotel arrangements, may be considered franchises under Canadian law, even if not so intended or characterized under American law. Why that matters is because the consequences for failures or errors of disclosure include statutory misrepresentation and rescission, including the right to sue for losses. Canadian franchise laws are historically strictly construed against franchisors, with case law supporting large damage awards against hotel franchisors because of, in some cases, technical errors in disclosure. While the substance of the disclosure is relatively similar in both countries, Canadian disclosure obligations include an overriding materiality concept, which requires FDDs to be modified on a deal-by-deal basis to account for deal-specific facts, including in some cases the content of a PIP, as well as ongoing disclosures in respect of material changes. This leads to a much less of a sort of set it and forget it type of compliance program that some franchisors may be using in the United States, and the likelihood for ongoing and transaction-specific disclosures. There are exemptions from disclosures in the provinces of Ontario and British Columbia, for example, where the acquisition of the franchise exceeds $3 and $5 million respectively. This year, considering the COVID-19 pandemic and its profound impact on the hotel sector, franchise disclosure obligations have had to be examined in new ways, with franchisors disclosing things like financial performance details in a much more real-time manner, as well as creating ways to support their franchise systems and individual franchisees through economic and contractual relief and other measures. In other cases, we've been assisting our franchisor clients enforce and terminate some of these agreements, and no doubt we will continue to see this as the pandemic unfortunately continues. We can move on to the next slide, please. A little bit more fun, cannabis law. As of October 2018, it has been legal to cultivate, possess, acquire, and consume cannabis and cannabis products across Canada. Permitted products include cannabis and cannabis accessories, and as of October 2019, edibles, which include cannabis-infused products, including beverages and vaporizers. The legal framework which regulates cannabis consists of federal, provincial, and municipal laws and regulations. And because of this decentralization to the provinces, it has created a lack of uniformity across this country. For instance, consumption in public areas is prohibited in some provinces, while in others, like Ontario, you're permitted to consume cannabis anywhere that tobacco smoking is permitted, with certain exceptions. Certain provinces, like Alberta, have created rules to permit the regulation of consumption spaces, like lounges or cafes, while others have not. And I know that just this week, the province of Manitoba has invited input from the public to gauge demand for retail consumption spaces, again, including things like lounges. The buzz around the equity markets and the explosive growth and value of many publicly listed pot companies in Canada has taken a major dip in the last 12 months. On the other hand, retail expansion continues, especially in this province, Ontario, and perhaps because of stay-at-home orders related to COVID-19, recent reports are that Canadian consumption of cannabis is way up. In my view, all this points towards a much more stable and sustainable growth trajectory for the industry at large. I'll note that in Ontario and British Columbia, as well as other provinces, cannabis can be smoked in designated guest rooms in hotels, motels, and inns. Local or municipal governments, however, may impose further restrictions on that. And while it's not mainstream yet, cannabis-oriented tourism and hotel options do exist, and it's not at all unforeseeable, at least to me, that the larger hotel chains will look to incorporate consumption options that may be akin to something like the old traditional lobby bar, as on-site consumption rules loosen up over time. We have many clients that are interested in this, so this is something that we are closely watching at our firm. I'll now pass it on to Jason.
Thanks, Frank. So let's talk about things you may not know about Canada in the world of employment law. So in Canada, there is no at-will employment, okay? An employer in Canada can't just terminate an employee without cause unless you give notice. And notice can be given by way of actual working notice, where you say, hey, you're stop working in 2 weeks' time, or pay in lieu of that same working notice period and have the person leave immediately. And while you're permitted to terminate an employee for cause without giving any notice at all, you got to know that cause is a very high threshold under Canadian law, and it's not successfully argued on a very frequent basis. In other words, the employee has to have done something really bad. The minimum amount of notice that must be given is going to be set by employment standards legislation, and those statutory minimums are going to vary across the country because it's province by province. But you can take as a rule of thumb that we're talking about roughly 1 week of notice or pay in lieu of notice for each year of service up to a maximum of 8 weeks. If you don't have a valid employment agreement that limits the amount of notice you have to give on termination to the employment standards legislation minimums, then the courts are going to impose a common law obligation to give what they call reasonable notice, okay? And this is going to be based on a whole number of factors such as age, length of service, the position performed, and like really what are the prospects for this person securing alternate comparable employment. And there's no easy rule of thumb here as to how much that might be, but I can tell you that 1 month of 1 month per year of service and even more is pretty commonplace in these types of orders in Canada. And all this is to say that it's really important in Canada to have written employment agreements with all your employees so you know what happens and what you owe on termination. It's good to know that employment standards legislation cannot be contracted out of. A lot of people have tried to do that. They get slapped pretty hard by the courts and typically end up owing what's called, as I said before, the common law reasonable notice period, which is always going to be typically more costly than what you would owe under employment standards legislation. Very significant is that earlier this year, right near the beginning of COVID, there was a case in Ontario that essentially put a lot of the termination provisions that are in existing employment agreements way into jeopardy. In short, the court said that if there is any provision in the employment agreement that is somehow inconsistent or contrary with the minimum requirements set out in applicable employment standards legislation, then that termination provision that you have in your employment agreement that would have otherwise been enforceable and that said, hey, we only have to pay you the minimums, is going to be thrown out, and you're going to be stuck dealing with the common law concept of reasonable notice, which will be more expensive. As you can imagine, this is going to be significant and real in terms of expense for employers in Canada. We're right now waiting to see if the Supreme Court of Canada is going to hear an appeal. A lot of our employer clients have, definitely gone back to look at their agreements and fix them so that going into new employment agreements, this issue is being addressed. As far as existing employment arrangements, It's not always so easy to amend these agreements. You need to pick the right time and place where there's consideration and the employee fully understands what's going on. But we do have some clients looking at finding the right opportunity now to amend past agreements. Others are just waiting to see what the Supreme Court's going to say. So that is a little background and an update as to what's happening on employment law in Canada. Next, I want to talk about destination marketing fees. Many of you have probably been watching this Canoe 3 versus the Best Western and others class action here in Canada. It's been going on for a few years. By way of background, for those of you who don't know, similar to the US, it's not unusual for local tourism authorities or hotel associations in Canada to collect fees and use those fees for the purpose of promoting tourism in a particular city or region. The contributions may be funded by the hotels in whatever manner the hotel sees fit and may come out of working capital, but they usually take the form of a percentage surcharge on the quoted room rate. Surcharges referred to as destination marketing fees or marketing fees are going to be collected voluntarily by the hotels. These are not based in any statute. They're not a lodging or accommodation tax, totally voluntary. Now, the next thing you need to know is that in Canada, a consumer has to be provided with a clear and unambiguous notice of the destination marketing fee prior to the consumer entering into the contract, buying the room. Fee must be disclosed as a separate item or a charge and can't combine it with like a tax or any other amount payable by the consumer. And in this ongoing class action, the plaintiff is claiming kind of two things. First, well, a number of things, but most significantly, that during the booking process on the hotel website, the destination marketing fee was characterized as a tax in some instances. In other instances, it's claimed that during the booking process, there was a misleading or incorrect disclosure as to what the destination marketing fee was, or in some instances, what the applicable tax was. And I think this is in part because some of the platforms that were being used just couldn't break out the destination marketing fee on its own line. In other instances, in order to add it as a surcharge, the only option was to add it in with the tax category, so it got lumped in with the tax, which was an issue. In other instances, it's alleged that the tax wasn't properly applied on the full rate of the room with the destination, with the fee. So all these things combined, many different claims in there. By way of update, a number of the franchisors in the action brought a motion for summary judgment, which was to, let them out last year. And on the basis that they were saying, hey, we didn't own or operate these websites. These are the franchisees' issues, not ours. In August last year, the court dismissed the summary judgment motion. And so this case continues, and the next expected major step will be certification as a class action. It's not moving at a quick pace at all, but something to be watched. And I know many of the participants here probably have a stake in this action. There's a second action that just started this year. It was first commenced in January 2020 in Quebec. The name of the plaintiff is Shafiq Mahoubi, if you've heard of it. This relates to what's otherwise known as drip pricing here in Canada. We haven't had one of these cases in the hotel world yet. We've had it in other spheres, but not hotel. Plaintiff alleges that the initial price quoted on the website was less than the final price disclosed at the point of purchase. It's alleged that the practice is a breach of both Quebec Consumer Protection Act, which is a provincial statute, and the Competition Act, a federal statute. In many of the instances described in the claim, the compulsory fees that were resort fees. They weren't initially disclosed, but then were added into the final price at the point of sale. And this is going to be part of what's at issue in this case. As you can imagine, because of COVID, not a whole lot's happened since the claim was commenced earlier in the year. But if you have business here in Canada, you're going to want to be monitoring that case. Loyalty program. So here in Canada, if you got a loyalty program, there some recently enacted laws in Ontario back in January 2018 and in Quebec last August 2019. And these laws are regulating loyalty programs and subject to some prescribed exceptions. The new laws prohibit the expiry of reward points due to the passage of time alone. We're expecting other Canadian jurisdictions, provincial jurisdictions, to follow suit with similar type legislation. So if you got a loyalty program here in Canada, that's something you should be reviewing at this point and considering the impact of these new laws. Last item I want to bring up about things you may not know about Canada is on the M&A front. So acquisitions of U.S. hotels, base hotels, are probably always completed on an asset deal basis, not on a share deal basis. But sometimes in Canada, we do see share deals, and there's a specific reason why that is. In Canada, there's what we call a lifetime capital gains exemption that's available in certain situations, where an individual can get basically 850,000 Canadian dollars tax-free on the sale of an asset if they meet all the requirements. And so you'll see, and one of those requirements is that the sale is the sale of shares. So sometimes you'll see vendors looking to structure these deals as share deals, and it's something that sometimes catches U.S. transaction lawyers or transaction business people off guard. We've got lots of more things to talk about at the deeper dive sessions. Most importantly, more information on how to navigate all the COVID-related legislation and COVID-related issues that are coming up with many of our clients. We look forward to seeing you and chatting deeper with you on some of those issues at the deeper dive. Thanks for your time. Back to you, Taylor.
Frank and Jason, thank you both so much for joining us. We really appreciate your insight into everything Canada. If you are watching this and you want to be able to join them at their Deeper Dive Roundtable, they will be hosting that roundtable on Thursday, October 8th, and we will be sharing that agenda with you so you can be sure to join them. Thank you guys both so much, and we'll be talking to you soon.
Thank you.
Thanks, guys.